With more than 6,000 members, PLUS promotes education and networking through chapter programs, regional symposia, and our international conference. We strengthen the skills of industry professionals through the PLUS curriculum, PLUS University, and RPLU program. Through the philanthropic force of the PLUS Foundation, we bring people together to improve our communities and share the rich experience of contributing. PLUS, the quintessential source of information and education on professional liability. Visit us today at plusweb.org.
My name's Tom Baker. I teach law at the University of Pennsylvania, where among other things I conduct research on securities class actions. The documentary that you're about to see presents the rise and fall of Bill Lerach in his own words. Bill Lerach pled guilty to a federal felony charge relating to secret illegal kickbacks paid to plaintiffs in securities class actions. In the summer of 2008, I interviewed him at his home in San Diego. The questions came from people on all sides of the securities class action arena. Our goal was to let Bill Lerach tell us, in his own words, what motivated him, what propelled him to the very top of his profession, and ultimately what led to his downfall.
A lot of people are willing to have their reputations ruined and spend a few years in a country club facility if they can put $100 million in their pockets. I know some that would do it for a lot less. Corporate executives and their accountants should keep in mind the old biblical admonition. What would it benefit a man to gain the whole world and lose his soul? Or I might add, his freedom.
Bill Lerach had nothing to do with the cleanup of corporate behavior.
I'm always troubled to hear anybody raise the argument in any context that the ends justify the means.
The way that our legal system here in this country is premised is that when people say things under penalty of perjury, it actually means something.
I always said that it was like Dean Acheson's book, Present at the Creation. We just happened to be here when Silicon Valley erupted, which I think was about 1981 or 1982. But we were here, we were on the ground when you had the first great public offering wave and the first great venture capital wave.
Well, there were certainly a lot of go-go years there. I mean, you really had the beginning of what became the tech bubble or the dot-com bubble that ultimately burst in 2000.
The stocks were new, they were hot, they were volatile. It was a whole new way of being a public company.
You had a lot of companies that had never really made anything, had never made a profit, and yet they were trading at multiples higher than some of the largest companies in the United States.
But what was really made these companies different was stock option compensation, which was new and evolving. As a friend of mine once said, it was a good idea going bad. It created all the wrong incentives for executives because of the tremendous pressure to insider trade and therefore to manipulate your numbers and results short term. So I think all those factors figured into it, and it was the Wild West. But I'll tell you the case that really seasoned us and established our credibility. And it's funny, it was not really a securities case as such. It was what was known as the United Methodist Church case, where we represented 2,300 elderly, and I mean elderly people, who were residents in Methodist Church-sponsored life care communities. The church had sold life care contracts at very cheap prices. The Vietnam War inflation had destroyed the economic model. It had become a Ponzi scheme where people were going in and making their lifetime payment. It was being used to pay that month's bills rather than escrowed. The whole thing collapsed. It was a huge scandal, and you had 2,300 people who'd been promised shelter, food, and unlimited medical care for the rest of their life, threatened with being turned out on the streets. The Methodist Church, for whatever reason, turned its back on them. We prosecuted the case vigorously for about 4 years, scored a complete and total victory after the case was largely tried. We got all their money back for them. We saved the homes. That case established our bona fides, our ability to do good work, and it made me realize that I could overcome any adversary. We grew up in a family, I used to say, of used cars and hand-me-down clothes. You know, we're unspeakably ordinary. My father died when I was a young kid. My mother was a widow, protected by Social Security benefits, got a scholarship to Pitt, was a very mediocre student as an ordinary, you know, undergraduate student, but I got to law school and that worked, that fit. That was what I was meant to be doing. I did very well and, of course, predictably went to work for a big white shoe, you know, conservative defense law firm in Pittsburgh. But it wasn't what I wanted to do. I didn't want to represent U.S. Steel and Carborundum and Alcoa and Mellon Bank, and I wanted to sue those guys. I wanted to be an advocate for people, not a protector of corporations. That's just the way I felt about it. My father was a very, very conservative, I used to say made John Calvin look progressive. I don't know why. I mean, I love my father very much. He never really amounted to very much. He graduated at the time of the stock market crash, lost all of his small inheritance. It ruined him as, in terms of a business career. And yet he was always so loyal to the establishment that I sort of felt had rolled over him. And I resented that. So that left a feeling and a desire to sort of strike back a little bit, even the score. We dominated this field. There was a public company explosion. It's sort of, I used to say, like putting AstroTurf in the football field in the community. The orthopedic surgeon gets a lot of work once AstroTurf is put in. Once you had all those public companies, you were going to have a certain amount of fraud, a certain amount of misbehavior, and that would generate cases and work for us. And we were off to the races, and we grew very rapidly.
You had a very aggressive trial bar that had developed a very sophisticated way to sue prosperous companies anytime their stock happened to gyrate a little bit.
We could fight anybody. You could not outspend us, and you could not outlitigate us. You might beat us, but it wouldn't be because we didn't have the capital or we didn't have the brains to fight you.
I think what was going on was the threat of a lawsuit. It became an economic equation. It was easier for them to pay the tariff to avoid the lawsuit, even when they were blameless or guiltless, than it was to take the publicity, the distraction of a major lawsuit on corporate managers. So through the 90s, with few exceptions, people capitulated to the demand. It was really a form of legal extortion.
This was a bill that was long in coming because everybody was becoming more and more aware of these, what they call strike suits. And it was in the guise of protecting the little guy or the little investor or against the evil corporations. And Lerach and that whole crowd played that exceptionally well. They got a lot of media attention. Media was fawning all over them because they were taking on the Goliaths. And the more you dug into it, you realized that there was something really phony going on here. And ultimately we found that out later. In terms of kickbacks and payments under the table to these so-called investor plaintiffs.
The PSLRA was enacted not to improve this kind of litigation, but to destroy it. And the law of unintended consequences was that when plaintiffs' lawyers realized that they now needed to get control of a case, the largest investor or largest loss, guess what? They started to go out and market and reach out to institutional investors.
I do believe that some of the work that was done on behalf of the plaintiffs was important work, and that they created a voice for people who don't normally get that kind of representation. But I beg to differ in the sense that you don't get there by cheating the system.
Look, the fact of the matter is, ethical rules are written by lawyers in big law firms and judges who came from big law firms, and they're written to create a legal environment that protects powerful interests. It's that simple. That's the way it is. That's why the rules against runners and cappers existed. It wasn't to prevent frivolous litigation, it was to prevent any litigation. Who made the original legal rules? Well, it was the king and his court. It was the king's deer that couldn't be poached. It was the king who couldn't be criticized. Legal rules exist to protect the rich and powerful in society. We were up against that. We were battling that. That was our challenge, and that was the life that we had to live.
Essentially, it came about like this. Stephen Cooperman was a serial plaintiff for Milberg Weiss. Between 1988 and approximately 1997 and 1998, he served as a plaintiff for them, filed approximately 70 cases. They earned hundreds of millions of dollars in attorney's fees with Cooperman. By 1992, Cooperman was in serious financial trouble, and so he needed to find a way to come up to pay off his debts. He owned a Picasso and a Monet, and he hit upon the idea of staging a fake theft of the paintings against which he would make a fraudulent insurance claim. Cooperman had taken out insurance on the two paintings, and he'd grossly overinsured them. And what he did is he had an attorney friend, a man named James Tierney, quote, break into his house while Cooperman was away and take the paintings. And when he got back from a vacation, he reported it as a theft to the police and made a claim. The insurance companies initially refused to pay, correctly suspecting that it was a fake. Cooperman sued, and ultimately they reached a settlement whereby he got $17 million. Cooperman wasn't so fastidious, though, about what actually happened to the paintings, and Tierney gave them to an associate of his named J.J. Little, who had a cocaine habit. And Little moved back to Cleveland, and he put the two paintings, the Picasso and the Monet, in a storage locker. One day, he got into a fight with his girlfriend. His girlfriend called the police. The police arrived. The girlfriend proceeded to tell the police about what a louse her boyfriend was, how he'd hit her, how he had a cocaine problem, and, oh, by the way, he's got a Monet and a Picasso sitting in a storage locker that are part of an insurance scam. And by the way, did I tell you what a louse he is and how he slugged me? And the police, I think, realized that this was something more than an ordinary domestic dispute. The police contacted the FBI. The FBI initiated an investigation, and ultimately they got a hold of Little, who agreed to cooperate, who then eventually rolled up James Tierney, the attorney friend of Cooperman, who actually engaged in the staged theft of the paintings. And ultimately that led to Cooperman in a criminal trial in the summer of 1999, at which he was convicted.
I knew that there was going to be trouble one day when I picked up the newspaper and saw that a former client of our firm, when I read in the paper one day he was cooperating with the prosecutors, was going to get 18 months in jail and was going to get to keep the $20 million. You didn't have to be Einstein to figure who they were coming after.
His attorney essentially went to him and said, look, you're going to be looking at a lot of time. The only way you're going to be able to reduce that is if you have anything to give the government. And as it happened, he had a few things to say about Milberg Weiss.
I always said to people as that was going on, boy, I sure wish we had the grand jury to haul people in front of and threaten them with perjury and offer them immunity. I mean, the tools available to prosecutors, it's pretty awesome. And then goes with it the prosecutorial discretion to decide what to charge. Are you going to charge for one thing, or are you going to break it into 32 counts? And all of a sudden, as a defendant, you know, you're looking at 25 years in jail and a $100 million fine because some prosecutor decided to structure that kind of an indictment and rely upon the testimony of disgruntled former partners and immunized witnesses. Well, that's the way the criminal justice system works. It's not pretty, and it's not fun to be on the other side of it.
I think anybody who is being investigated by the federal government and the Department of Justice would probably say that. But what it means is that the federal government has a multitude of resources. You have the IRS, you have the postal inspectors, you have the FBI, and so we have resources in which we can actually investigate and make sure that all those rocks get turned over.
The investigation became known to Milberg Weiss and its principals no later than January of 2002, and certainly you had perjured statements and continued kickback payments well into 2005.
The investigation was over. It was going away. The claims were barred by the statute of limitations, and the evidence was weak. And unfortunately, as the case may be, the government stumbled on something that had gone on in Florida, was not known to me, certainly was not known to any of my California partners, that one of our erstwhile New York partners had chosen to continue to behave in the old ways, if I can use that euphemism, even while the investigation was going on. And I'm sure that the prosecutors were rightly infuriated when they found out about that. I know I was infuriated, and I wasn't a prosecutor.
The way that our legal system here in this country is premised is that when people say things under penalty of perjury, it actually means something. And it was galling to me that individuals who were members of the bar, who practice in these courts every day of their lives, would actually come in and make false statements. Witnesses were lying in their depositions when they were asked whether or not they were being paid as plaintiffs. Pleadings were filed that had false statements, and the judges were basically making decisions based on misrepresentations. And you can't have that in our system of justice.
The sharing of fees with plaintiffs was an industry practice. It went on. Anyone who says otherwise isn't telling the truth. I don't know why it went on. As such, I know when I encountered it some years later at the firm, I didn't know about it when I started, and I asked about it. I said, why are we doing this? The answer was, because we have to. We're not voluntarily giving away a part of our legal fee because we want to. I mean, we weren't a church or a charity. We were a profit-making institution. We did it to meet competition. We did it because that's what was done in the field.
No, it was never understood to be acceptable, and to the contrary. Melvin Weiss was approached, my understanding is that he was approached by an individual who wanted to serve as a plaintiff, and the individual demanded to be paid cash in connection with bringing the case to Milberg Weiss and serving as a plaintiff. And Mr. Weiss related this information to his other partners. One of those partners, David Burshad, did some research and came across criminal statutes which had been on the books for years, expressly forbidding these sorts of payments. And when this partner, Mr. Burshad, brought it to Mr. Weiss and said, you know, there is a criminal statute that expressly forbids this, among other things, Mr. Weiss's response was, we're paying in cash, no one will ever find out.
Now, you have to make a judgment. Do you want meritorious cases to be brought and litigated or not? Well, we made the judgment that we wanted the meritorious cases brought, because if they're not brought and the plaintiff isn't compensated for bringing them, then justice will not be done. Wrongdoers will not be held accountable. Victims will not be compensated. As I say, it's controversial. I know people vehemently disagree with it, but that's the real world that we operated in, and that's the way it was.
That is an insidious justification of criminality. It is not common practice. It was never common practice. What Bill Lerach did was file false affidavits to a judge. You know, when I became a lawyer, I took an oath. I became an officer of the court. In that oath is a commitment never to lie to a judge. In my entire life, it would not occur to me to lie to a judge.
sometimes you have to endure things that aren't great if you think there's a greater good. It may have been the ends justifying the means. It may, with the benefit of hindsight, seem stupid or reckless. But when it was going on, nobody, and I mean nobody, ever thought that what was going on was criminal in any way. Now, we knew it was ethically improper. Okay, it just was. It was against the rules. Whether you liked the rule or not, it was against the rules. It was kept secret, not because it was criminal, but because the defense bar, had they had it, would have used it with pro-corporate judges to destroy the cases and prevent meritorious cases from being brought. The plaintiffs' firms knew it was going on, but they wouldn't expose one another because they were all doing it.
I'm always troubled to hear anybody raise the argument in any context that the ends justify the means, because that causes one to, first of all, we're all going to have different assessments of the relative morality of the end that they're seeking. There are many who think that Milberg Weiss and these individuals were not really pursuing any greater good, that what they in fact were doing was simply lining their own pockets through filing essentially extortionate lawsuits. Those individuals may be right, they may be wrong. I can't imagine that each and every one of these lawsuits that was brought by Stephen Cooperman or Seymour Lazar involved actual fraud.
Corporate abuse by venal corporate managers, and there were clearly some of those in the cases prior to 2002, does not justify criminal conduct by a lawyer who cloaks himself in the posture of a reformer, when in reality he's simply using that wrongdoing to benefit himself. Bill Lerach had nothing to do with the cleanup of corporate behavior. The Sarbanes-Oxley bill was an appropriate government response to the kinds of abuses that were manifest during that system. That bill would have happened whether Bill Lerach was making his private gains or not. Not much of the money that he recovered found its way back to shareholders. Much more of it found its way to Bill Lerach's law firm's coffers.
The world is imperfect, it's not pretty, and that's the way it is. So if I've disappointed a few people, I'm really sorry for that. And I hope they pick up the cudgels and go to work and represent people and achieve the results that we achieved.
What amazes me is how many letters were submitted looking for leniency for Bill Lerach from former judges who are now invested in the system as mediators, who profit from this system. I can't reconcile how a former judge who knows how insidious it is if lawyers lie to him, to the system, could ask for leniency. What Bill Lerach did to the judicial system in this country is about as offensive as possibly could be done by any lawyer.
One reads of Lerach as the profane bully, the egotistical megalomaniac. Fortunately, in my own personal experience, I never saw that. I thought in my own personal dealings with Mr. Lerach, I thought he showed tremendous dignity and showed great grace in dealing with a circumstance that for him was very personally devastating. In his letter to the court, he wrote about the prosecutors, myself included, that even though I disagreed with them on many things, they were straightforward, honest, and fair. And I was gratified by those comments, because the job of a prosecutor is not to get a conviction, it's to do justice. And when one of the defendants is writing to the court that the prosecutors were straightforward, honest, and fair, then you know you've done your job.
I don't know. The cynic in me says that they all profit from a system which Bill Lerach helped perpetrate. That's a pretty cynical view, though. I think based on personal interactions with the guy, he's a likable guy. I mean, we used to have him in Chubb to instruct our D&O examiners on the dynamics of a securities class action lawsuit. And I think it's a natural human reaction to want to help somebody who's in trouble.
I found a line of work that fit my political and economic views, worked hard at it, got good results for my clients, made a lot of money for myself doing it in a free enterprise system, and made some mistakes along the way for which I will pay grievously. someone else will have to decide what the legacy is for that. Now that's a great flower. That's a fuchsia. Look at that. It's an amazing flower, isn't it? Grows like a weed here. I garden like crazy. This is a great and very unusual flower. You don't see very many blue flowers. It's called Bromfelsia, the shady lady. Has to be in shade virtually all the time. So we spend a lot of time with our flowers. Flowers don't talk back to you. They're nice. They're friendly.
I think the money is so tempting and the sums at issue were so great that it's easy for someone like Lerach or Weiss to convince themselves that it's really nothing more than jaywalking, when in fact deep down they know that the opposite is completely true. And you do it long enough and you engage in it enough times without getting caught that you begin to think that maybe you're covered with a little Teflon and you'll never be caught.
Hi guys, how we doing? The never-ending project. I think by the time I'm back from prison it'll be finished at the rate they're going.
I don't know what converted Bill Lerach from the do-gooder that he says he originally was, if we take him at face value, to an avaricious, cynical perverter of the judicial system, which is what he became. You know, was it money? Greed? I don't know. Did he begin to believe his own press? Probably a little part of that we all do, I suppose.
So how are you guys preparing for your going away?
It's all right. I've had months to prepare, so it's okay. You could go to a lot worse places than Lompoc, which is where I'm going, up near Santa Barbara. Look, what we did was wrong. We made a mistake, but we did it, and we'll suffer the consequences for it. All right, guys, we'll see you. I got put in a very tough position. I had to make a decision as to whether I wanted to risk my firm, my partners, my fortune, and my freedom. So just like when I was a litigator, I made a lot of tough, calculating decisions. I made a decision that the best thing to do was plead guilty, take my beating, and get on with my life, and that's what I did.
In the Greek tragedy, the protagonist's strengths fuel his rise and his fall. Here, Bill Lerach's determination, his devotion to the craft of lawyering, his anger at the system, and his skill at persuasion, very much on display in this film, fueled his rise. But they also fueled his fall, because they allowed him to persuade his most important audience, himself, that the ends justified the means.